On March 15th, the three-judge bench of the Karnataka High Court dismissed a batch of petitions filed by Muslim girls studying in pre-university colleges in Udupi. They were seeking the right to wear hijabs inside classrooms. In the 129-page verdict, there were 4 concluding points. Number 1. Hijab is not an essential practice in Islam. Number 2. Prescribing uniforms is an institution's right. And number 3, state order not discriminatory, although it could have been better drafted. And number 4, there will be no case against college authorities. How did the Karnataka High Court come to this verdict? The High Court framed 4 broad questions to take a holistic view of this matter. The court held that there is no Quranic injunction on wearing the hijab and that wearing the hijab is not religion specific. The court's inquiry was to ascertain whether wearing the hijab is so essential that if not followed, one could not practice the religion. The court said, quote unquote, "It is not that if the alleged practice of wearing hijab is not adhered to, those wearing hijab become the sinners. Islam loses its glory and it ceases to be a religion." The court also said that the petitioners did not submit sufficient evidence to prove that wearing a hijab is an essential religious practice in Islam, and it said the material presented was extremely meager and the petitioners' averments were vague. Quote unquote, "We have no affidavit before us sworn by any Maulana explaining the implications of the surahs quoted by the petitioner's side." The court said it is well established that schools may prescribe the dress that students should wear. While the petitioner's argument was specifically about allowing students to wear hijab of a structure and color that suited the prescribed dress code so they continue with their education, the court stressed on the institution's right to prescribe a dress code and said, quote unquote, "We are not impressed by this argument. Reasons are not far to seek. Firstly, such a proposal, if accepted, the school uniform ceases to be uniform. There shall be 2 categories of girls: students, those who wear the uniform with hijab, and those who do it without. That would establish a sense of social separateness which is not desirable. It also offends the feel of uniformity which the dress code is designed to bring out amongst all the students regardless of their religion and faiths." On the example of Kendriya Vidyalayas allowing the headscarf, the court said that states need not follow the center. Quote unquote, "What the Kendriya Vidyalayas prescribe as uniform or dress code is left to the policy of the central government. The federal units, namely states, need not toe the line of center." The Karnataka government order issued on February 5th under the Karnataka Education Act 1983 said that colleges can restrict students from wearing hijabs. The petitioners had asked the state to show how the mere wearing of the headscarf will constitute a public order issue. To this, the court appeared to suggest that the word of the government order must not be construed literally. Along with unity and integrity, the order cited public order as one of the grounds for not allowing students to wear a headscarf in educational institutions. Quoting Oscar Wilde, the court said that there is room for improvement even in heaven. Point number 4 focused on whether any case is made out against the lecturers and principal of the college in Udupi, where the hijab controversy first began. This was a contention raised in one of the writ petitions filed by Advocate Tahir Muhammad, associated with SDPI, the political outfit of the Popular Front of India. The petition sought action against the principal and teachers of the college for violating the departmental guidelines which prohibit the prescription of any uniform and for their hostile approach. The court rejected the contention, saying, quote unquote, "The petition is apparently ill-drafted and pleading lack cogency and coherence that is required for considering the serious prayers of this kind. We have already commented upon the departmental guidelines as having no force of law. Therefore, the question of the said respondents violating the same even remotely does not arise." A Muslim student, Niba Naz, had approached the Supreme Court against the order, saying it had failed to note that the right to wear a hijab comes under the ambit of expression and is thus protected under Article 19(1)(a) of the Constitution. On Wednesday, the Supreme Court refused to grant urgent hearing to the petitioners and said it will hear the matter post Holy Recess. With Apurva Vishwanath, this is Charulata Biswas for the Indian Express.